Our next case, I lost my cover sheet here somewhere, is Riccelli versus Rector. Each party will have 15 minutes to present the argument. Counsel, you may reserve time for rebuttal. How long would you like to reserve?
Your Honors, I'd like to reserve 5 minutes.
Okay. I will be keeping the time up here. You cannot see it, so I'll let you know when you're down to 1 minute in your initial time. And then if you go past that time, you'll just take off your rebuttal time. When you do your rebuttal, I will not let you know how much time is left in that. You'll just let me know at the end of time.
Okay. Thank you.
I will let you know 1 minute left in your time as well. The arguments are being recorded. When you present your argument, please introduce yourself. Keep your voice up. Remain behind the podium. Please make sure you introduce your client as well. You should not use the name of all children, minors, or victims during the argument. I don't know if we really have here, but if we do have any victims, make sure we use initials rather than full names. We read your brief. I'm ready to proceed whenever you are.
Thank you, Your Honor. And thank you for allowing me to appear in place of Mr. Bruce Hall. He's back in the office. He has some medical issues, so he's getting back up to speed. Thank you. Attorney Eric Hall here on behalf of the appellant Tracy Riccelli, Your Honors. This case involves a wrongful death case. It was the appellant's daughter, Jordan Riccelli. She passed away in 2018. Case today involves, I believe, a very narrow issue involving Rule 41A and the statute of limitations. Case was filed, initial filing. First case was voluntarily dismissed without prejudice. There was a second case that was filed, okay, and that was within the time frame for under 41A. That case was dismissed by the court for failure of service. The assignment of error in this case is the court erred in granting the most recent motion for summary judgment filed by the appellee in this case. But in the second case, Your Honors, the case was dismissed by the court for failure of service. The appellee in this case, Nicholas Rector, was serving a sentence of incarceration related to this case. And that complaint was sent by certified mail to the prison facility. It was signed for by a prison official, and that's also, I believe, attached as part of the exhibit in the response for summary judgment, and also in, I believe, in its appeal as part of the record. I believe what happened was sometime thereafter it was rejected, which I quite frankly don't understand how you can accept service and then at some point in time reject it later on. I think the law is clear on this, that the person required to, there's no specific person at a prison required to accept service. It says, I think the statute case law says a prison official. So in that doesn't have to be the warden, that could be the warden's secretary. I even think that could be a corrections officer, it's not specific. So then the case was refiled again, and then that case was then dismissed by the court on summary judgment. I believe it's beyond the statute of limitations. I believe that the second dismissal in this case was an error by the court, though, because I don't think the second dismissal implicates the double dismissal rule.
Can we review that in this case, though, and would that have been appealed at the end of the second case?
It wasn't appealed, Your Honor, it was not. But I would argue to this court that that second dismissal was it doesn't exist under 41A because it was dismissed by the court for failure of service. It says without prejudice. It wasn't on the merits, and service was made on that case. So actually the double dismissal rule would not apply. The second filing would be the second, the third filing would be actually the second filing in this case, which was a valid filing, which would be within the savings statute. Obviously, it was beyond the statute of limitations. I mean, this case began back in, the victim in this case died in 2018. The appellant is the mother of the victim, suing the appellee on behalf of the estate of her daughter.
Would that what I'll call the third case for our purposes today, was that within 1 year of the first case that was initially dismissed, that refiling?
Oh, no, Your Honors.
So to get to the savings statute, you'd have to try to get back to the second case, which you're saying wasn't properly denied.
That's correct, Your Honors. That's correct. The trial court erred in dismissing that because it's clear, and my review of the record, my review of documents, that service was made on that case. without a doubt.
But if we get rid of the second case and say, okay, that was wrong, and assuming we even can now, but let's say we say we're going to somehow reach that even though it wasn't appealed, we'd be now taking the third case that should have been filed within a year of the dismissal of the first case, but wasn't, so the saving statute wouldn't apply.
Well, under the circumstances, under strict interpretation of saving statute, you're correct, Your Honors. And also, it is beyond the statute of limitations. There's no doubt about that because of the time involved. But because of the trial court's error in dismissing the second filing, okay, they're the ones that the trial court created this problem. They were in error in dismissing that case. Had they not dismissed this second filing, that was within the saving statute, and the case could have proceeded on its merits, so whatever the decision or outcome would have been on the merits, Your Honors. And that's, I think, what the problem is in this case, is the second dismissal in this case by the trial court. It wasn't voluntarily dismissed by the appellant, plaintiff. It was dismissed by the trial court, and it was dismissed for failure of service. That service had to be made perfected within 6 months. They said it wasn't. Clearly, it was. I mean, there's an exhibit that shows that service was made, was accepted at the prison facility. And so the trial court erred on that. So that placed this case in the situation it is today, that it's beyond the statute of limitations, that's clear. And also, if you were to accept the second dismissal as a dismissal under 41A, it will be outside the saving statute also, because of the first dismissal, first case. So we're asking the court in this case to correct that error that the court made on the second filing, the refiling, in dismissing that case for failure of service when service was perfected in the case, Your Honor. And like I said, I think it's a very narrow issue. I think it does. The case cited by the appellant is Olenek versus Scholes, the double dismissal rule, but I don't think the double dismissal rule applies in this case because of the intermediate dismissal by the court for failure of service on the refiling of the case, the second filing. And I think that the court should go back. We're asking the court to go back and not treat that as a valid dismissal by the court under 41A or under the other circumstances as a sua sponte dismissal by the court for the wrong reasons. The court was in error. And we'd ask the court to remand this case back to the trial court for further proceedings. Thank you.
Thank you. Seeing no questions, you have the remainder of your time for rebuttal.
Okay, thank you.
Or your 5 minutes for rebuttal, excuse me.
May it please the court, counsel, Mr. Riccelli. My name is Frank Mazguy here on behalf of the appellee Nicholas Rector. I agree with Mr. Hall that there is a very narrow issue for the court to consider. I think what the Supreme Court did in McCullough versus Bennett when this issue was addressed is they kind of made out, it's actually in the opinion, as the court is aware, a diagram of the filings and when the statute of limitations ran. Obviously, there have been many cases since McCullough that have interpreted cases in which 2 or 3 filings were applicable and whether the saving statute applies. In this case, unfortunately, Ms. Riccelli passed away on December 17th of 18. The only claim that has been asserted throughout against my client in this case was for either negligence or battery and wrongful death, which would be a 2-year statute of limitations, regardless of which of their claims apply. And that becomes important given some of the cases since McCullough has been decided. We'll look at claims in which a 2-year statute and a 4-year statute is in the various claims, and in applying the saving statute, some of the claims were saved that were subject to the 4-year. But in this case, I think it's important for the court's consideration that only a 2-year statute of limitations applies. The first lawsuit was filed 2 days before the 2-year statute of limitations ran. That case remained pending for approximately 1 year, and was dismissed on December 13th of 2021, which would have been after the statute of limitations had run on all of the claims in this case. A month and a half later, the second lawsuit was filed on 2/1/22, again, after the 2 years had elapsed.
Counsel, do you agree, though, the second case that was filed on 2/1/22 was within the saving statute, so it's timely?
I believe, yes, the saving statute would have applied to 2/1/22 to effectively extend the statute of limitations period.
Okay.
But it was not within the 2-year statute of limitations, which expired on December 17th of 20. That second lawsuit included some additional defendants, given that there was a claim that my client, based upon a rather significant injury when he was in high school, became addicted to pain medications and then started to use illicit drugs. Those other defendants subsequently were dismissed, I think, by a summary judgment in the case. That case then was dismissed by the court on December 4 of 2023. So that case remained pending for about 21 months. And any allegation regarding a service issue could have been cleared up during that period of time. They could have tried service by publication, and they could have indicated to the court to reconsider its decision in the case, or it could have appealed that ruling. They
Counsel, how would it appeal the ruling on a dismissal without prejudice?
Well, Your Honor, if Mr. Hall is correct, and I would question him a little bit on that, but if it was dismissed sua sponte by the court without any action by the appellant, that entry of which the case was dismissed did have the Rule 54 language in it, and it was the ruling upon, as I recall, the motions for summary judgment of the other defendants. There could have been a motion filed with the court to reactivate the case. I think an appeal could be filed if the court on its own improperly dismissed it.
But there generally is no appeal for a motion for a dismissal without prejudice.
For if the court sua sponte were to do that?
Well, the whole point is without prejudice, because that means you can refile.
Well, Your Honor, I'm not sure that the court used that language
Okay.
in its entry, but even so, I think at that point in time, I mean, I could claim, I guess, to dismiss a case without prejudice, even though this court could say to me, no, that was your second dismissal. Just because you say it is that, Mr. Mazguy, that doesn't make it so. So in this case, then, 3 months later, which was 3 years and 3 months after the statute of limitations had expired initially, and if we apply the saving statute to that second filing, this lawsuit again would have been filed 3 months after that extension. So I would ask, my client now is almost 5.5 years, if my math is correct, after the horrible event which gave rise to this case, and is still subject to the claims in this case, and has had to defend now 3 different lawsuits in those cases. I agree that the saving statute has been utilized and it is there to extend effectively the statute of limitations, but it's there to effectively extend it one time. In this case, there is no dispute, it has been extended twice. This is not the case that McCullough had where the second lawsuit was filed within the statutory period. In this case, the second lawsuit was filed subsequent to the 2-year statute and the third case as well. Based upon that and the reasoning in McCullough and the cases that have been decided since then, I would ask that the court affirm the ruling of the trial court and rule that the claims against my client are time barred. Thank you for your time.
Seeing no questions, thank you, Counsel.
Thank you, Your Honor. So briefly, the trial court's entry on the dismissal of the second filing of the complaint that was dated on December 4, 2023 says judgment entry with instructions to the failure to obtain service. It is therefore ordered a judge and decreed that the plaintiff's complaint is dismissed without prejudice. Plaintiff Tracy Riccelli shall pay the court costs of this action for which judgment is rendered and execution may be issued, signed by the Judge Joyce V. Kimbler. That was part of the plaintiff or appellant's response to the defendant's motion for summary judgment, and that was filed. This plaintiff's response was, appellant's response was filed on March 5th of 2025. So that second filing was dismissed by the court sua sponte without prejudice. So I would argue to the court that that doesn't operate as a 41A dismissal. It's not a voluntary dismissal. It's not a dismissal on the merits. And basically what it's done in this case, it's caused this issue to become before this court. Had the trial court simply realized that service had been made, okay, and if you look at the documents, the exhibits, it's clear it was made, okay, it was signed by somebody in the prison. Why the court ruled that service wasn't made, I don't know. It doesn't indicate in the judgment entry. Just as plaintiff was given the opportunity to show cause why service was not obtained within 6 months after the filing of the complaint, service was made. That's why we're here today, because of the error on the court on the second filing. It should not have been dismissed. We wouldn't be here. The case would have proceeded on the merits. However, that would have turned out. We would have given the appellant the opportunity to proceed on the merits. That's all the appellant wanted in this case, was to be able to proceed with this case on the merits. And also an old case, a tragedy that happened with her daughter back in 2018. I understand the passage of time, and I agree it's been quite a while, but it shouldn't. The passage of time shouldn't deny the appellant her day in court, and that's what the second dismissal by the court, sua sponte by the court, not a voluntary dismissal. And I think that that should not implicate the double dismissal rule. That should not affect the saving statute, where the third filing would have been within the saving statute, that's the reason for the third filing, because of the court's erroneous dismissal. So I'd ask the court to take that into consideration.
If your client had voluntarily dismissed the second case,
I'm sorry, Your Honor?
if your client in this case had voluntarily dismissed the second case, the trial court didn't make an order, but your client said, I can't get service, I'm dismissing, and then tried to refile. Under McCullough, would that be appropriate? You then would have had your, this is a dismissal. The second time you tried to use the saving statute, could they have dismissed their own action and tried to use the saving statute?
I would think that McCullough would apply in that case, Your Honor. I think that the third refiling, if the case is voluntarily dismissed twice by the plaintiff or appellant, I don't think that you get a third refiling under those circumstances. But that's not what happened in this case.
Well, I'm just trying to deal with the fact we had the second case that you said the trial court made a mistake on, and okay, fine, but no one appealed.
Right.
Or tried to take any action in that case and say, trial court, you've made a mistake, I got service.
Sure.
And so how do we deal with that in that circumstance?
Well,
do you file a whole new case, or you're supposed to be trying to challenge that somehow in the first case?
Yeah, and maybe this is a case of asking for the court to make a decision maybe on a first impression. I read the ruling in Olenek versus Souls. I think it's somewhat convoluted. It's, to get through this on the double dismissal rule, it's not, some legal gymnastics, I would say. But in this case, I think it's clear that there was an error made by the trial court, and that was on the second filing, Your Honor, and I would ask the court to take that into consideration and rule in appellant's favor and send us back to the court for further proceedings. Thank you. Thank you, Your Honor.
Thank you for saying any questions. The court will take the matter under advisement and issue a decision in due course. The clerk court will mail a copy of that decision to you upon its release, and it will also be posted on the Ohio Supreme Court's website. With that, I'd like to thank both of you for your presentations today on behalf of the court. And I note that the court is now adjourned until